Thank you.
The gentleman from New York is recognized for 5 minutes of question.
Thank you, Mr. Chairman. Mr. Sauer, did you discuss the substance of your testimony here today with any members of this committee? Yes. Can you turn your microphone on?
I participated in a briefing yesterday afternoon with members of the subcommittee when my testimony had already been finalized.
And were any Democratic members included in that briefing?
I can't say for sure. I don't know all the members who were involved.
You don't know?
I don't know. I'm not as familiar with the membership of the committee as perhaps I should be.
And am I correct that, I'll just note for the record, there were no Democratic members in that briefing. But am I correct, sir, that you are one of the lawyers that brought the lawsuit that we are discussing here today?
That is correct.
So you're a party to that case?
No, I'm an attorney. That's very different.
Well, you represent Louisiana. You work for the Attorney General's Office of Louisiana, and Louisiana brought the case?
That's correct. It would be inaccurate to describe me as a party.
Okay. But you don't decide whether or not your arguments that you make in that case and that you're making here today are valid or not, do you?
They seem very valid to me. The judge will make a decision in our case.
The judge makes the decision, right?
Correct.
Not you. And as you know, the district court did not decide in its opinion whether your assertions are correct, right?
The district court dismissed the pending motion to dismiss by the Department of Justice, saying that we'd alleged sufficient facts to state claims, and we'll have a hearing in late May on our pending motion for preliminary injunction. He has not ruled on that yet.
Just so lay people can understand, a motion to dismiss just says that if the allegations that you make are true, you can continue with your claim. A preliminary injunction will actually address the evidence that you're discussing, right?
That's correct.
Okay. Now, are you expecting that the Department of Justice will appeal the motion to dismiss order?
You would have to ask them. Well, actually, the motion to dismiss order, it's very unlikely because there is no procedural right to appeal that. And so far, they haven't made any attempt to do that. It would be they would have to do that by pursuing what's called an extraordinary writ. That'd be very unusual. That said, I do not speak for them.
Do you read the news, sir?
I'm sorry?
Do you read the news?
Some news.
Are you aware of reporting that Donald Trump's defense attorney asked Republican members of the House of Representatives to intervene in an ongoing criminal investigation into himself in a local prosecutor's office?
I don't recall reading that.
Okay. If that were the case, would you consider that to be called, quote, directing, unquote, that the House of Representatives act on behalf of Donald Trump?
I would have to know many more facts before I'm able to make any kind of judgment like that.
Right. All right. Well, I just wanted to understand, because you talk a lot about directing here, that the government is directing, but then you also say that there's a compelling inference. Now, we lawyers understand that inferences only occur when you don't have direct evidence to support it, so I would also just want to note that.
We have overwhelming direct and
there's no
indirect
question.
evidence.
The sad reality here is that we are continuing to go down this phantom narrative that the White House or the Biden administration coerce social media companies into censoring anti-vaccine and election disinformation and misinformation. Now, we know why that is, because the members on the other side of the aisle believe that that disinformation and misinformation, if it gets out there, is politically beneficial to them. But unfortunately, neither you nor they have presented any direct evidence to support this. But I would actually submit that this hearing is more notable, not because of the topic and the witnesses, including 2 who were too afraid to stay and answer questions, but because of what we are not focusing on. Apparently, this committee is no longer focused on the so-called dozens and dozens of FBI whistleblowers who were supposedly going to show some massive government conspiracy to attack conservatives. 3 of them have now come in for transcribed interviews over a month ago. Where are those witnesses, Mr. Chairman? Let's bring them in. Bring them in right here so that the American people can see for themselves what the entire basis of this subcommittee is. Now, you want to talk about censorship? You imagined in your opening statement a world where the FBI sends a list of books that should be pulled from their shelves. Luckily, we don't have to imagine that, sir. Are you aware that recent laws in Florida have resulted in the mass removal of books that are now banned in public schools?
I don't know about Florida. I do know that we have sworn testimony from FBI agent Elvis Chan that directly backs up the analogy I drew in my opening statement.
Okay, well, you should go look
Gentleman's
into
time's
this.
expired.
You should go look into it because Florida right now is banning books, and you would agree that's a violation of the First Amendment.
Gentleman's
wouldn't you?
time's expired. Gentleman's time's expired.
Can the
And
witness
since-
answer the question? Would
No,
you
because you were
agree?
over your time. And because you addressed the chair, I'll tell you, stay tuned, Mr. Goldman. There's much more to come in this committee. The gentlelady from Florida, Ms. Kamick, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you.
Top administration officials. Mr. Chairman, I yield back.
Chair recognizes Mr. Goldman from New York.
Thank you, Mr. Chairman. I'd love to get the extra minute that Mr. Fallon got as well. Thank you guys for being here today. We don't have a lot of time here. I have a lot of questions. If I cut you off, I'm not trying to be rude. I'm just trying to get through them. And I want to talk a little bit about the evidence you did have. Mr. Ziegel, you were the case agent. So how many documents would you say you gathered during the 5-year investigation?
So, however, I do believe I may have documents. I am limited by the statute, but I would be more than welcome to turn those documents.
No, I don't
over
need
to
them.
the-
How many? Just the number.
It was a significant amount of documents. I apologize.
Hundreds of thousands? Millions?
I don't want to put a number to it, but there was a lot.
Right. Bank records, right? You had a lot of bank records,
Yes,
both domestic and foreign,
that is correct.
and you conducted search warrants?
Yes, there was reference in our transcripts to conducting electronic search warrants.
And did you do other search warrants as well?
When you say other search warrants, what do you mean?
Any other search warrants? Electric, otherwise, physical?
So I'm going to stick to what I stated in my transcript. There were multiple electronic search warrants.
And
that
you
we
said that you
executed.
conducted more than 60 interviews as part of this investigation, is that right?
That is correct.
That's a lot for any investigation, right? For a tax investigation?
I wouldn't say that.
Yeah?
I would say that
All right, in
more-
my 10 years, I don't know how many investigations I did with 60 interviews. So I want to focus, though, for a second on the WhatsApp that we went through. And Mr. Shapley, in your testimony, your opening statement, you said that the text message, the WhatsApp message that we've been talking about, shows Hunter Biden discussing business with his father. Could you show me where in the text message it says anything about discussing business with Joe Biden?
So if you'd like me to go through it, I mean, I can take time to review it if you'd like me to.
Well, I don't have the time, unfortunately, as you point out. I will tell you the only thing it says about it is that Hunter Biden was sitting with his father. It does not say anything about discussing any business. And Mr. Shapley, you also said in your testimony, and we've talked about this a bunch, that the agents were prohibited from pursuing leads related to Joe Biden and the big guy, but the agents did that anyway, right?
The
Interviewing Rob
agents
Walker.
interviewed Rob Walker.
And they
did
asked him
not
about
use
that, right?
The word big.
Right, they didn't use the word big guy, but they asked about it in reference to that text. And do you recall that Rob Walker actually said in response to that he was not aware that Joe Biden was ever a part of anything that he and Hunter were doing?
That's what the witness said, yes.
Yes. And then you describe a lunch, what we talked about earlier, where Joe Biden came to say hello at the Four Seasons Hotel to lunch that he was having with CEFC executives, right?
That's correct.
But what you didn't talk about is what Rob Walker said the origination of that lunch was. And you testified that he said that Hunter told his dad, according to Rob Walker, quote, "I may be trying to start a company or try to do something with these guys." Now let me ask you something. That doesn't sound much like Joe Biden was involved in whatever Hunter Biden was doing with the CEFC if Hunter Biden is telling him that he's trying to do business with them, does it?
No, but it does show that he told his father he was trying to do business, and he was
Okay,
talking
well,
to
that
his
is
father
true. Hunter Biden
about the
does
business.
try to do business. That's correct. Yes. So you not only have no direct evidence connecting Joe Biden to any of Hunter Biden's business deal, you actually had proof that he wasn't involved. That is the proof that you had. And in the end of the day, that this was a 5-year criminal investigation with tens of thousands of documents, maybe hundreds of thousands, unusual warrants, aggressive techniques, you wrote a report recommending felony charges. It went to DOJ tax. They wrote a 99-page memo, approval memo, right? And neither of you saw that, did you?
That's correct.
That is correct.
And what was their recommendation?
So all I know
Approval,
is,
discretion, or declination?
so I have to stick to the
Okay,
confines of.
you testified that it was discretion, which means that it wasn't an approval, it was to the discretion of the U.S. Attorney's Office, which had that DOJ tax memo, which had information from the defense lawyers that they spoke with, and they are the ones who have to prove this case in court. And I will tell you, as a federal prosecutor for 10 years, and I worked with many of your colleagues who do great work, and I'm sure you do great work as well. But I never met an agent who didn't want to charge every possible case. But what I noticed in 5 hours of testimony today is that neither one of you has ever mentioned a portion of the case that may not be so strong, or may be suspect, or may have a defense. And that's because that's what the prosecutor has to think about before charging a case. And that is not what the special agent report does.
Gentleman's
So,
time's
in the end-
expired. He went a minute over. Chair now recognizes
Thank you.
Mr. Perry from Pennsylvania.
I thank the
My time, because what I really want to talk about here is evidence. Evidence, evidence, evidence. Mr. Johnson was so eager to talk about what he called the hard evidence, and yet all we heard again was him repeating allegations without identifying any evidence. You can repeat all of these allegations as much as you want, but it doesn't make them true.
Well, gentlemen,
you
you-
are not witnesses. I don't have enough time, unfortunately. You are not witnesses to any of this conduct, and just because you say it over and over, it doesn't make it so. And if we're talking about censorship here, which I believe is presumably the reason why Mr. Kennedy is here, the tweet that you've identified was never taken down. Whatever the government may have tried to do, and I don't agree that it tried to do what you said it did, it wasn't taken down. So how can the government actually censor anyone if there's enough freedom within the companies they're talking to that they reject whatever request that the government makes? I want to focus now, Ms. Morris, on the laptop. There's been a lot of talk about the laptop being real. And that is true. There was a laptop. It's a computer, keyboard, screen. It is real. But you never got a laptop before you wrote that story, did you?
That's correct.
You got a hard drive.
Hard drive.
And you received that hard drive from Rudy Giuliani, right?
Yep.
Who had been openly associating with an agent of Russian intelligence in the months leading up to your story. You agree with that, right?
I guess.
Now, did you do a forensic examination of that hard drive before you printed your story?
We had tech people in the Post looking at it, yes.
That's a
I don't-
forensic analysis?
No, not.
I
what
highly
does that
doubt the New York Post has the ability to do a forensic analysis of a hard drive. Ms. Morris, were you the primary drafter of this article?
Yes.
Bruce Golding was not the primary author?
No.
Drafter?
No.
Did he help with the article?
Yes.
And then isn't it true that he decided to withdraw his name from the byline because of concerns that he had?
I wasn't involved with that.
Well, isn't it true, whether you were involved in it or not?
I don't know the details.
But he did withdraw his name from the byline.
His name was not published.
Right. Well, I'd like to introduce for the record an article in the New York Times that says, the first line is, New York Post front page article about Hunter Biden was written mostly by a staff reporter who refused to put his name on it, two Post employees said. Now, I would note, you also said that this article was determinative of the election, but there was a pause for 24 hours, and there was a tremendous controversy. And there is no doubt that this article received far more attention because of the controversy than it would if it had ever been published without any controversy. And it is odd to hear my colleagues and Ms. Morris talk about their somehow expert knowledge about whether it affected the election, because we're not hearing a lot about Jim Comey, although one of my colleagues did say that he interfered in the 2016 election, and that is correct. He interfered on behalf of Donald Trump against Hillary Clinton by unnecessarily announcing an investigation 6 days before. The majority would like us to believe that there's some broad government conspiracy, but in reality, this government is playing by the book. That is why Joe Biden's Justice Department has allowed a Trump-appointed U.S. attorney to continue his investigation of the president's son, which is in direct contrast to what the former president did by weaponizing the Justice Department. And I yield back.
Gentleman yields back. The chair now recognizes himself. Hard evidence. Mr. Johnson said that.
Gentleman yields back. Chair now recognizes Mr. Goldman from New York.
Thank you, Mr. Chairman. This hearing is entitled "The Basis for an Impeachment Inquiry." You would think that after 8 months of an investigation, we would not need to have a hearing with no witness who has any direct knowledge of the evidence to determine that there is a basis for this impeachment inquiry. And this is an impeachment inquiry. Mr. Turley and Mr. Gerhardt testified in 2019 in the official impeachment process in the Judiciary Committee. The inquiry was in the Intelligence Committee. And in the Intelligence Committee, there were 17 firsthand witnesses with direct knowledge of the allegations. And the public hearings had 12 witnesses, all with firsthand. Here we are in our first hearing. No one has any actual knowledge or evidence. There's nothing new here. So why don't we have some of the fact witnesses here? You've brought them in. They've come in already. What about Devin Archer? Now, Mr. Donalds and the chairman now want to disavow Mr. Archer's testimony that Mr. Biggs entirely relies upon, but they don't want him to come sit here. Why? Well, maybe because he testified that Joe Biden never discussed business with Hunter or other business associates, he got nothing from their businesses, and he never took any official acts related to the businesses. Or maybe the American people might hear that this $3.5 million from Batterina actually had nothing to do with Hunter Biden, which is what Devin Archer testified. Or what about Eric Schwerin, Hunter Biden's partner and accountant? He also performed a number of administrative and bookkeeping tasks for then Vice President Biden and Hunter Biden. He saw President Biden's bank accounts, and he told the committee that he was not aware of any involvement by President Biden in the financial conduct of his relatives' businesses, much less any transactions into or out of then Vice President's bank account related to business conducted by any family member. And the list goes on. We've already talked about Lev Parnas and Rudy Giuliani. The reason is you bring in the fact witnesses and your case goes down the drain. So let's talk about what your allegations are. $15 million to 9 Biden family members from 2014 to 2019. Mr. Dubinsky, was Joe Biden president of the United States from 2014 to 2019?
No, he was not.
And in fact, from 2017 to 2021, he was a private citizen, right?
That's my understanding, correct.
Mr. Gerhardt, am I correct that the framers made very clear that conduct as private citizens are best left for the legal system, not the impeachment process? Is that right?
Yes, sir.
Now, even yesterday, in releasing 700 pages of documents, Chairman Smith admitted that he's not an expert in the timeline, which seems to encapsulate this investigation to a T. Because here we are seeing texts and emails from 2017. We're seeing Department of Justice emails from 2020 when it was the Donald Trump Justice Department. And all we hear all day long, Biden family, Biden family, Biden family. And every time you hear that, you know that it doesn't include Joe Biden. If there were 9 Biden family members who got money from these business transactions, isn't it striking that Joe Biden was not one of them? Pretty remarkable. And what we hear is this is an exceedingly complex chain of transactions. That's what the House Republicans said. Pattern of incredible financial complexity. Ms. McClain showed a chart. It had a investor. It had an investment company that invested money, that received money, and then it went to the investors. Mr. Dubinsky, that's not very complicated, is it?
Well, that's not really the question. The question is, what was going on there? Was there an investment? What's the
I'm just asking about the structure.
Well, that
because
structure-
what we have here, and we hear so much about services and all of this, services are legitimate or product. It's an investment company. It's a private equity company that invests capital in other corporations and companies. That is standard practice.
Well, that's an assumption.
Mr. Turley, you said in 2019 that impeachment requires a clear criminal act. Is that right?
No, in fact, in the Trump impeachment, I said repeatedly, you can impeach someone for non-criminal conduct. What I said then, I'm saying now, which is I strongly encourage you to look at criminal
Yeah.
acts.
All right. Well, that testimony is there.
But
But
can I-
let's
can I
just, no, you can't because I have 10 seconds left. You have said that lying as a president is not impeachable. You have said that there's an influence peddling campaign, but you will acknowledge, will you not, that in order to have a criminal act of public corruption or bribery, there must be under McDonnell an official act in connection to some sort of personal benefit. Isn't that right?
Gentleman's time's expired, but Mr. Turley, please answer the question.
Yeah, I can just point you to my testimony. I talk about quid
Just
pro
answer the
quo.
question.
Because it's a little more complex.
No, it's not. An official act for a personal benefit.
Gentleman's time's expired.
Chairman, point of order, down here. Mr. Chairman.
Chair recognizes Mr. Donalds for
a point
5
of
minutes.
order,
You'll
Mr.
have
Chairman.
5 minutes.
It's
You'll
not
have
my
all
5
the
minutes. A
time
point
you
of
want.
order
No, you're
is
out of
not within
order.
5
You're
minutes.
out of order, Mr. Goldman.
I have a
when
point of
your
order.
when your time is,
I
you will
asked
be
to
recognized.
introduce
Chair
something by
recognizes
unanimous
Mr. Donalds
consent.
for 5 minutes.
Is it being introduced?
Chair recognizes Mr. Donalds for 5 minutes. Byron, it's your
Chairman,
time.
the rules require you
Thank
to
you, Mr.
recognize.
Chairman.
No.
Yes, for a point of order, they absolutely do.
Chair
And you have to
recognizes
rule
Mr.
on
Donalds.
the motion.
And as
You've
Mr.
already
Donald's
made
time
2
ticking
points
too?
of order.
No,
Chair
Mr. Donald's
recognizes
time
Mr.
is not going
Donalds.
to take. Actually, Mr. Chairman, I request its clock be set back to 5 minutes
Set
so we
the
can.
clock back to 5 minutes.
Mr. Chairman, can I just make a parliamentary inquiry then? Are we not to make points of order on either side during
You
the
keep
questioning?
speaking about no evidence. Why don't you all just listen and
I'm
learn?
trying to introduce evidence.
You've already introduced. You've already had your
Is it in?
share of evidence.
Are you
Now,
admitting
Mr. Donalds, 5 minutes.
Thank you, Mr. Chairman.
But I would urge you to yield to Mr. Goldman.
I will yield to Mr. Goldman.
Thank you very much. I thank my colleague. Ms. O'Connor, I believe you testified before that the 99-page DOJ tax memo gave a full authorization for the charges. Is that your testimony?
That is what the whistleblowers reported.
Actually, the whistleblowers reported that it was a discretion finding. And since you worked in the DOJ tax division, I'm sure you understand that there is full authorization, there is discretion, and there is declination. And when they give a discretion determination, that is because there are serious holes and flaws, and they leave it to the discretion of the U.S. attorney whether or not they want to charge it. Isn't that correct?
No, not at all. Discretion is not based on holes and flaws. It's based on the ability of that particular district to prosecute that case. And in fact, that 99-page memo is
ability?
referred
What do you
to
mean the
several
ability?
times in the
Excuse me,
testimony.
excuse me.
And
What do you mean-
and
what do you
only
mean
in
the
one
ability?
time did it mention discretion. All the other times it did not mention discretion at all. And
So you're
suggesting-
disputing that it said
Gentleman's
discretion.
time. Gentleman's
Are you
time is
disputing that it said
expired. Chair
discretion?
now recognizes Mr. Palmer from Alabama for 5 minutes.